Have you ever wondered how ordinary citizens can hold the government accountable without being personally affected? Hello, this is Ayantika, your legal faculty here at CLATapult, and in today's video, we are going to talk about one of the most powerful legal tool, that is Public Interest Litigation or PIL. This is a story of how Indian courts transformed themselves from passive arbiters into protector of public rights. From prisoners behind the bar to polluted rivers to vanishing forests, PILs have changed the face of Indian justice. So the idea of PIL wasn't just born overnight. It began in the late 1970s when the Indian Judiciary realized that access to justice shouldn't depend on money or status. Traditionally, only a person whose rights have been directly violated could approach the court. But judges like Justice P.N. Bhagwati and Justice V.R. Krishna Iyer redefined this and opened the courtroom doors to any public-spirited citizen. The spark came with the landmark case of Hussainara Khatoon versus State of Bihar, 1976. The case began with a newspaper article exposing that thousands of under-trial prisoners were languishing in Bihar jails for years without any trial. A public interest litigation was filed, and the Supreme Court held that the right to speedy trial was a part of Article 21, that is, the right to life and liberty. This single judgment led to the release of over 40,000 under-trial prisoners, and this was the birth of PIL in India, a revolution in legal access. After that, the floodgates opened. Throughout the 1980s to 1990s, PILs had become a voice for the voiceless. In S.P. Gupta versus Union of India 1981, a court formally recognized that any member of the public can file a PIL in case of social injustice. In Vishaka versus State of Rajasthan 1997, the court laid guidelines against sexual harassment at workplace long before Parliament enacted a law. In MC Mehta cases, the Supreme Court transformed the environmental laws from cleaning the Ganga to introducing pollution controlling norms and vehicular emission standards. Through PILs, the court protected bonded laborers, street children, women, and even animals. In short, PIL became people's weapon against power. But like every powerful tool, even PIL started being misused. Some people started filing PILs for publicity, vendetta, and political gains. Courts began calling these publicity interest litigations. In Subhas Kumar versus State of Bihar in 1991, the Supreme Court warned that the PILs should not become a tool for personal interest. Later, in State of Uttaranchal versus Balwant Singh Chaufel in 2010, the court laid down strict guidelines to prevent frivolous PILs. Because when PILs are misused, the genuine cases are usually buried under the sensational headlines. So today, PILs have evolved. We see them being filed for environmental protection, LGBTQ rights, digital privacy, clean air, and even AI regulations. For example, the most recent PILs have pushed for better air quality in Delhi and also accountability in digital privacy. But the future of PILs depend on balance. Balance between judicial activism and judicial overreach, and also between people's voice and the court's limits. So, PILs work best when it is used for genuine collective goods, not as shortcuts to publicity. Thank you and see you in the next video.